Thank you very much for staying with us. Now, suspended Public Protector Busisiwe Mkhwebane wants to appeal the ruling that effectively keeps her from returning to office. Western Cape Judges Lister Nuku, Francis and James Lekhuleni have ruled that the Constitutional Court must okay their order to overturn Mkhwebane's suspension before it takes effect. To discuss this further, we're joined by legal expert Benedict Phiri. Mr. Phiri, good morning and thank you very much for your time as always. Now, before we get to the application for leave to appeal, can we start with the application to execute the order which was dismissed? If we all remember, Ms. Mkhwebane's legal team had brought it in terms of Section 18, subsection 1 and 3 of the Superior Court Act, which speaks of exceptional circumstances or irreparable harm that could be visited on the applicant. Did you believe exceptional circumstances existed in that instance?
Yeah, I think, when you look at the case she made out, she didn't really articulate what the exceptional circumstances would be, other than to say that she needed to go back into the office to finish the work on the Para investigation specifically. And also she couldn't justify what irreparable harm would be, if she wasn't put back into the office, because remember, she is suspended with full pay and pending the outcome of the Section 194 inquiry. So I think that was always going to be a tall order of an application for her to make outside of, the constitutional process in its own around the confirmation of that order.
Now, in as much as, if we remember correctly, the acting public protector's interest in the case was dismissed, one assumes that if she were to say she wants to conclude the Pala investigation, it would assume that in this instance, her legal representatives were trying to place the individual before the office, because many would think the work of the PP continues even in the absence of the current public protector.
I think that's exactly correct. And you can see that in the judgment of the court in the urgent application that, it cannot be that it is an individual that is elevated to complete this particular investigation. And we had the acting public protector in the replying papers saying that actually there has been progress and the president has responded and, the investigation continues. So I don't think it would have been right to elevate her particular person to conduct this investigation as opposed to the office of the public protector. And in as much as the intervention application was dismissed, but at least on record, we got an accounting of what has been done with respect to the Para investigation by the acting public protector.
Yes, and then to the judgment itself. Now, in dismissing the application, the court reiterated its position that its ruling has no independent existence, but it's conditional upon the confirmation by the Constitutional Court. Just talk us through what exactly that means.
So there was a question around the interpretation of two parts of the order specifically relating to the setting aside of the president's suspension and what flows from that. And, the court said, look, ultimately what we're doing is setting aside the exercise of the power by the president under the Constitution. You cannot look at it any other way and say it lives under a separate part of our law and doesn't touch the Constitution. And all the orders that are attached to that, including that she should be reinstated immediately, flow from the exercise of that power. And for that reason, that order, because it is an order that deals with the conduct of the president as being unconstitutional, the Constitution is clear that it has no effect, or rather, as the court put it, it remains inchoate until such time as the Constitutional Court has actually confirmed that order. And for that reason, even an application under Section 18 of the Superior Courts Act could not be brought, because you don't actually have an order that is capable of being in effect and whose effects you would want to mitigate against pending the outcome of an appeal process.
But here we are, they're looking now to appeal that particular judgment, in as much as also when reading the judgment, the court went on to say they would assume that any reasonable person would understand or have an appreciation that any matter pertaining to constitutional invalidity has to be finalized in the apex court. But here we are, they are looking to appeal. What do you think they'll be relying on here?
Yeah, well, I think that is actually quite, and I think the court, as you said correctly, even said that, maybe as a future practice, courts should specify that, this order must get confirmed. But I mean, that is an automatic process in terms of the rules of the Constitutional Court. But when we're looking at that appeal, I think it is a bit of a tall order, because I think it is quite clear that what we are concerned with here is the conduct of the president, a constitutional power that he exercised. And I think the court made it also abundantly clear that this requires the intervention of an appellate court at the right particular level. So I also wonder what the strategy around the appeal is, given that the Constitutional Court has confirmed that it will hear this matter on the 25th of November. And that would be an opportune time to ventilate all these legal issues that have arisen, around is confirmation the right thing, and also is appealability, can that actually be done? And that can all be ventilated in front of the Constitutional Court on the 25th of November. I don't think it's necessary for there to be a plethora of legal processes, unless maybe the strategy is to keep pressure on the various processes relating to Parapara.
And then on the main case itself, the one that will be confirmed by the Constitutional Court, is a very serious case. I mean, that judgment itself was very damning. If you're going to have the court state that the president could have not reasonably brought an independent mind to bear insofar as the suspension of Ms. Mkhwebane is concerned, it's very serious. Do you see that particular matter being confirmed by the Constitutional Court in this respect?
It's very serious, and I think there will be some, countervailing arguments. I think there is the argument already around whether the courts have encroached on the terrain of the executive, in this particular instance, the president, to make such decisions without a test that you would apply, for instance, to judges and other judicial officers around bias. So I think that will be, some testy legal arguments that will be made around that. But I think the big question really is around the rule of law, and around whether the head of a Chapter 9 institution can be suspended in circumstances where the president's conduct can be brought to question. And I think that will also invite substantial arguments. So I can't say which way it will go, but certainly there will be heavy contestation in those particular areas.
But wouldn't you say that reasonable apprehension of bias is easier to prove than actual bias itself? So in this instance, it wouldn't be saying that there would be, or he would be biased, but there would be reasonable apprehension from ordinary citizens, including the public protector, given that there would be some level of conflict.
I think it is an easier test. That's correct. It is an easier test than full-scale bias. But if you look at, for instance, a president or a cabinet member, in some instances, they actually can bring bias. They choose people in their cabinet, not necessarily on fully rational grounds. There's a preference that may go to style of working, or, insofar as making those kind of decisions are concerned, the courts usually defer to the executive for how they make them. But I think what makes this one, what elevates this particular one, is it's a constitutional power. And you'd expect that under all circumstances, a constitutional power is exercised, firstly, without the influence of a conflict of interest, which the court highlighted as well, and also without a reasonable apprehension of bias, because we'd want to make sure that when the president exercises a constitutional power, he's doing that from the strongest place that the law can afford him.
In the public space, there seemed to be a desire to conflate or compare this particular situation with that of the former president when he lost his right to appoint the judge or the chair of the Commission of Inquiry. Do you think that these two cases are similar in any way, for many to have now gone on to compare them?
I don't think that these two cases are similar, because in that particular instance, the former president was implicated directly with respect to the investigation that was going to follow from the inquiry. I think here what actually happened was the president actually became he created his own misfortune for taking too long to suspend the public protector, because the suspension had been in process.
Yes.
But what actually changed was the immediacy of the actions following the announcement that the former public, or rather the suspended public protector, had made that she would investigate the president. So that actually became his problem, and not necessarily whether he actually had a right to suspend the public protector or not. I think, until that particular moment, it was very clear that that right lay and could have been exercised at any given point in time. But the question was, why did he exercise it at that particular time? And that became the problem in this particular matter.
I know it remains a very interesting case. We cannot wait for it to actually sit in the Concord. Benedict, as always, thank you very much for your time.